claims under the Minimum Wages Act 1948, Section 20, Subsection 1. The appropriate government may, by notification in the Official Gazette, appoint any commissioner for workmen's compensation or any officer of the central government exercising functions as a labor commissioner for any region or any officer of the state government not below the rank of labor commissioner or any other officer with experience as a judge of a civil court or as a stipendiary magistrate to be the authority to hear and decide for any specified area all claims arising out of payments of less than the minimum rates of wages or in respect of the payment of remuneration for days of rest or for work done on such days under Clause B or Clause C of subsection 1 of Section 13 or of wages and the overtime rate under Section 14 to employees employed or paid in that area. Subsection 2. Where an employee has any claim of the nature referred to in subsection 1, the employee himself or any legal practitioner or any official of a registered trade union authorized in writing to act on his behalf, or any inspector or any person acting with the permission of the authority appointed under subsection 1 may apply to such authority for a direction under subsection 3, provided that every such application shall be presented within 6 months from the date on which the minimum wages or other amount became payable, provided further that any application may be admitted after the said period of 6 months when the applicant satisfied the authority that he had sufficient cause for not making the application within such period. Subsection 3. When any application under subsection 2 is entertained, the authority shall hear the applicant and the employer or give them an opportunity of being heard, and after such further inquiry, if any, as it may consider necessary, may without prejudice to any other penalty to which the employer may be liable under this act, direct. 1. In the case of a claim arising out of payment of less than minimum rates of wages, the payment to the employee of the amount by which the minimum wages payable to him exceed the amount actually paid, together with the payment of such compensation as the authority may think fit, not exceeding 10 times the amount of such excess. 2. In any other case, the payment of the amount due to the employee, together with the payment of such compensation as the authority may think fit, not exceeding 10 rupees. And the authority may direct payment of such compensation in cases where the excess or the amount due is paid by the employer to the employee before the disposal of the application. Subsection 4. If the authority hearing any application under this section is satisfied that it was either malicious or vexatious, it may direct that a penalty not exceeding 50 rupees be paid to the employer by the person presenting the application. Subsection 5. Any amount directed to be paid under this section may be recovered. Clause A. If the authority is a magistrate, by the authority as if it were a fine imposed by the authority as a magistrate. Or clause B. If the authority is not a magistrate, by any magistrate to whom the authority makes application in this behalf, as if it were a fine imposed by such magistrate. Subsection 6. Every direction of the authority under this section shall be final. Subsection 7. Every authority appointed under subsection 1 shall have all the powers of a civil court under the Code of Civil Procedures 1908, 5th of 1908, for the purpose of taking evidence and of enforcing the attendance of witnesses and compelling the production of documents, and every such authority shall be deemed to be a civil court for all the purposes of section 195 and chapter XXXV, that is 35 of the Code of Criminal Procedure 1898, 5th of 1898.